Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. Like I try and do each and every Thursday night. I haven't been here for, I think it might even have been 2 weeks. I was on vacation last week up at one of my favorite places to go, which is Lake Powell, up on the Utah-Arizona border. If you haven't been there, if you haven't seen it online, go check it out on YouTube. I actually have a YouTube channel called Explore Lake Powell. One of my sister channels has some really kind of cool stuff on there. You can go check that out. But I am back in the saddle again. I'm back here on the YouTube channel, here doing the live stream where we do the live Q&A each and every Thursday night. For those of you who are new to the channel, again, my name is John Skiba. There it is, right there at the bottom. I am I guess you'd call me kind of a consumer protection attorney in the state of Arizona. I do consumer bankruptcy cases like Chapter 7s, Chapter 13s. I also help people who are getting sued by junk debt buyers, whether it's portfolio recovery, LVNV, Midland, all those guys, anything debt related I deal with. So what I like to do on the channel, and the whole reason why I created the Consumer Warrior YouTube channel, was to provide some information to people, kind of help point you in the right direction, and maybe kind of get things, the juices flowing a bit as far as some of the defenses you have and ways to deal with problems. The number one thing I see when people, they get sued by a debt collector or they're dealing with overwhelming debt issues is they don't know what to do. And so they get into a situation where we go to the worst place, thinking we're going to jail and all that kind of stuff. There's no jail. We're just dealing with money here. It's stressful, but it's something that we can absolutely put a plan together, understand your options, understand what creditors can and can't do, and put yourself in a much better position going forward. So if you have questions, if you're watching this on YouTube or Facebook, go ahead and put it in the comment section. I'll put it up on the screen and we'll discuss it. My caveat, each and every time we do this, while I am a licensed attorney in Arizona, I'm not licensed anywhere else. You need to take this for what it is. Some guy talking on YouTube. If you need real legal advice, if you're in the state of Arizona, my number is scrolling along here. I also put a link in the chat section. You can schedule an appointment if you're in Arizona. I can do consultations for bankruptcy, debt collection lawsuits, that kind of thing. If you're not in Arizona, you can still click on there. We can help point you to an attorney in another state who can help you with the issues that you're dealing with. So, all right. And before we get started, quick shout out to one of our sponsors of our weekly live stream, Solo Suit. There is a link in the chat section as well. Solo Suit, go check out their website. Click on that link. It's a great way to help support the channel. But they provide service, online kind of technological services. It's kind of like LegalZoom, but for consumer type issues, where if you need help drafting an answer to a lawsuit, those kind of things, you can click on there and they can show you. It's really slick the way they do it. It helps you put together, you provide the information, it puts together the answer. And then they even file it with the court for you. They have debt settlement services. Go check that out. They are some great folks over there. I also have some links to my Consumer Warrior stuff. You can go check those out as well. So, all right. We have a number of questions. And Christian Wannabe was here nice and early. So let's talk about his. Dear sir, I have had my wages garnished for at least 6 months. It's painful. And I'm considering having my lawyer finally file. If he's still around, already paid, I'm very concerned about not losing my music equipment and even carpentry tools. Now, my lawyer mentioned that there may be a way to pay the trustee to keep my instruments and tools, probably less than $5,000. Question is, okay, there's got to be a question. I'm not seeing the follow-up question, but let me tell you, you bring up some good points here. So just some background. This is a person who's looking to file for bankruptcy. The concern is a couple issues that they brought up. I mean, one, the garnishment for 6 months. If you file a bankruptcy, whether it's Chapter 7 or Chapter 13, it immediately stops the garnishment. So if you're dealing with that garnishment, and garnishment's heavy. Garnishment's one of the number one reasons that people actually just finally pull the trigger and say, let's do it. Let's file that bankruptcy case. So I would look at that as a way to stop that. But then the concern here is in the Chapter 7 bankruptcy, stops the garnishment, gets rid of all the debt, but then you're in a situation where they're going to look to see, do you have any assets that can be sold, and then the money going to your creditors. Now, in Arizona and in every state, there are exemptions, but they vary from state to state. So the exemption that you're worried about here, your music equipment, musical instruments in the state of Arizona, there is an exemption. It's not great. It protects up to $400 in value. I once did a consultation with a kind of professional level musician, and he told me, us musicians, we're used to getting the short end of the stick on this one. And it is, you know what? It's kind of funny. Like there's a firearms in Arizona have a $2,000 exemption, but musical instruments, it's a $400. So $400 of liquidation value, which doesn't go very far in the instrument world, but that would be protected. Now, tools, unless they're actually tools you use as part of your profession, there is something called the tools of the trade exemption that protects up to $5,000. And again, these are Arizona numbers. But if they're just general carpentry tools, kind of depends on what the liquidation value is. If we're just talking a few $100s worth of things, if you're going after my Ryobi collection that I use as a weekend warrior, no one's going to take that. If this is like expensive lathes and saws and things like that, it may be something they could go after, but it is possible. And this is pretty much uniform across the country. The bankruptcy trustee who's in charge of liquidating these, they'll often give you a chance to make an offer. So let's say that it was a musical instrument. Let's say it's worth $1,000. It's more than the exemption. You can make a cash offer, and some trustees in Arizona will even allow that to be paid over time. So where you can keep your stuff, get them some money to make a distribution to your creditors, and then you'd be okay there. All right, let's jump into Rio Jones says, should we initiate arbitration before filing a motion to dismiss, compel private arbitration in order to improve our chances of receiving a favorable design by the judge? Every week I do that. I've been doing this for years. Every week I lose my voice. I talk on the phone all day and then jump on this and for some reason can't talk. No, I would say no. And here's the reason why I would say no. Typically, that's not going to influence a judge. I should say this. In my opinion, is that you're just trying to enforce the agreement that the creditor has in place that gives you the option to do private arbitration. So assuming that the agreement's there, it's clear, you're doing it timely, they should just grant it. If you initiate a private arbitration case, that typically is not going to influence the judge. And like AAA, you have to pay $200 to do it. And so I wouldn't want you to waste $200. I would just file the motion. What in Arizona, typically what happens is the court will stay the court case and they'll say, okay, you got 90 days to go initiate it. And then you can go initiate it from there. So that's typically what I recommend, so you don't end up wasting any money with the private arbitration filing fees, that kind of thing. So, all right. Eric says, when asked to validate a debt collection letter, Midland Funding is a junk debt buyer, included a bill of sale and assignment with the price details redacted, along with an affidavit of sale. Was under the impression they never disclosed this. Is this new? No, I mean, I've seen them disclose the bill of sale. Now, it's important to realize the bill of sale, as much as they try to allege that it is, that is not the document that kind of governs the transaction between the two parties. The document that they typically don't disclose is something called the forward flow agreement. Or sometimes it's a purchase agreement that they reference in the bill of sale. That's a much larger document that goes into all the details as far as what's paid. It also has a lot of the disclaimers where they disclaim usually the accuracy of any of the documents that are being provided. So, but they'll usually provide that, which usually a one-page bill of sale. It doesn't reference any accounts, doesn't reference your name, doesn't reference your account number. And then the assignment is usually just something that somebody typed up. So, or the exhibit that's attached to it. So the affidavit of sale too, I often look at that. It's usually pretty generic. It just says that a group of accounts was sold from original creditor to Midland. Very rarely is it specific. So, all right. Franco Physique says, I got a motion for summary judgment from a debt collector. Could I file for arbitration with solo suit now, or do I have to respond to their motion first? This is a little bit tricky. And this is why I usually recommend, if you're going to ask the court to push it into private arbitration, you do it early. Do it, file your answer and then go ahead and get this into private arbitration. Because once they file the motion for summary judgment, there's some courts that may not grant your motion to compel private arbitration. Now, go look at your arbitration clause. And that's usually in the terms and conditions of the credit card agreement. If it states that, usually it'll state in there the time frame. And usually it says any party can initiate private arbitration at any time before judgment is entered. And so I would argue that, hey, the motion for summary judgment, it hasn't been granted. As long as it hasn't been granted, there's no judgment that's been entered, that there's still an opportunity to do it. Worst case scenario, you can file it, and what's the court going to say? No. I mean, that's literally your worst case scenario. I would definitely calendar out your response time on the summary judgment motion. So summary judgment, again, is them saying, hey, judge, we don't need trial. Just look at all these documents and tell us if we win. There's a timeline to respond to that. If you don't respond to it, the courts are generally just going to grant it. So I would not allow that deadline to go by without responding to it. Otherwise, you could end up with a judgment entered against you, and then for sure they're not going to grant it at that point. So let's see here. Innocent Loyal says, according to the CFPB, the Consumer Financial Protection Bureau, the contract says that arbitration is between myself and the seller. So they should not be able to sue on the breach of contract due to it not being in the terms of the agreement. The issue is, so this is the whole assignment issue, particularly with debt buyers. If there's a valid assignment clause in the terms and conditions, which there is in pretty much every credit card agreement, and they transfer it, then the buyer or the junk debt buyer, they essentially step into the shoes of the original creditor. So even though the arbitration agreement and the terms and conditions between them as the creditor and the consumer, if they do sell it and there's a valid assignment, then the debt buyer steps into their shoes and they are able to pursue it. So, all right, let's see here. All right. The good one says, question, could you cancel a bankruptcy Chapter 7 after filing a petition and attending the meeting with the trustee? Typically, no. Chapter 7 is like Chapter 13. That's the big long one, where Chapter 13 is like a 5-year process. One benefit it has is you can back out. You can voluntarily dismiss. Chapter 7, once you're in, you're typically in. The only times that Chapter 7s get dismissed are if you don't file the documents timely, or if you don't show up to your meeting of creditors. It can be dismissed. So if you've already filed the paperwork, it sounds like here you've already been to the meeting with the trustee, which is the meeting of creditors. It's very, very rare. I mean, sometimes people will file a motion to dismiss. It's hard because once you're in, the trustee kind of, they have their claws that they can try to see if there's assets to be liquidated. You can convert to a 13. So I've had cases where all of a sudden an asset comes up that I'm unaware of. You can convert it to a Chapter 13 and then deal with things that way. But yeah, unfortunately, it's that you're not going to be able to dismiss. All right, let's see what Scott says. Scott's been promising this is going to be a doozy. We'll see. We'll see, Scott. Said, I had a bank, In Touch Credit Union. They added forced insurance and charged me for it, even though I had insurance. Because of that, it tipped me into default because it raised my payments by half of what I was. I approved that it trashed my perfect credit. Goes on to say they repoed my car here in Texas, even though the arbitration clause says it has to be settled through Las Vegas, Nevada. They canceled my gap that would have paid them and immediately sought judgment here in Texas, despite the arbitration clause being in Las Vegas. And they gave me notice of nothing. Of course they did. That's how all these end up, is that notice is the biggest issue. They trample over your rights, but then they don't give you notice. Yeah, I mean, if there's situations like that. I mean, those are situations you need to find an attorney locally in Texas who can walk you through what you can do there. Because, when there's violations by the creditor, when it's not just hey, they're suing and it's a junk debt buyer kind of thing, but when they actually have taken action against you that can raise claims under the Fair Debt Collection Practices Act, Fair Credit Reporting Act, some of the federal statutes, as well as just normal breach of contract issues. Definitely, I would contact an attorney in Texas, have them review that, and get someone to be able to take a look at that and see what they can do to help you. That's kind of a mess there. Let's see. Freshness says, I am a disabled veteran with 100% VA payment and SSDI. Capital One used a law firm to sue me and got a default as I was never served. My money is protected by the federal government for up to 2 months. Will USAA garnish anything if it gets that far? So income is, I can tell you that so Social Security disability is completely exempt forever, not just the 2 months. My understanding is that the VA money is also, it's completely, it's exempt under federal law and under most state laws. The key to particularly Social Security, the one thing I tell people, because Social Security is given through a direct deposit. My recommendation is to have a separate bank account with the Social Security going into it, and then don't commingle it with anything else. Don't put any employment in there. Don't put the VA money in there. I would keep those things separate. That way, it's clear as to what's actually, it's exempt. Because in Arizona, we see this periodically where someone will get Social Security. They have like a part-time job. They put them in there together. And then the courts say, we don't know what Social Security and what's employment income, so it loses its exempt status completely. So depending on what state you're in, and maybe Freshness there, you can tell us what state you're in. There's also exemptions that protect bank accounts. Like in Arizona, $5,000 in a checking account is protected. So there is a way to do it. USAA, man, if USAA is garnishing our disabled veterans, the world's kind of upside down. Okay, so you say you're in Kansas. I don't know the exemptions there, but I as far as if the bank account exemptions, I don't think you're in any danger of getting for sure your Social Security is 100% exempt, and then the VA money should be as well. There's federal statutes to protect that. And I should say this, even though it's exempt, it doesn't mean that a creditor won't try to take it. So if they try to take it, then you have to raise an objection to it. I always say this, even though the law says creditors can't do certain things, it doesn't mean they're not going to try. And then if you don't raise an objection, it can be an issue. So if they do try, I would raise an objection, but I would just keep them, I would keep them separated. Don't commingle with anything else. I know you said there's no other employment income you're dealing with. So I would just try to keep those separate so that it's nice and clear and clean exactly what's exempt and what is not. Okay, so I'm being sued. PRS. I have not been served yet, and my court date is July 16th. Why does the court give them 120 days to serve you? It's past my court date. I don't get it. Okay, and maybe you can just say what state you're in. The states do this differently. I actually just dealt with the thing up in Utah, and they kind of do things. I think it's kind of screwy the way that they do. So like in Utah, they will file, they'll send a consumer a complaint and a summons, and they'll say, hey, unless you pay this in 10 days, we're going to file it with the court. And then once we file it with the court, then you have 20 days to respond to it. I don't get that. Like Arizona, they have to file it with the court. Then they have 90 days to accomplish service. And then it goes from there. So in this situation, I think what they try to do is try to move these things along a little more quickly. You need to find the rules of civil procedure in your particular state. You can just Google these, go to Google Scholar. But if they haven't served you, so what it may be that the court allows them to file the complaint, the summons, they give them an immediate court date, tell them to go out and serve you. And then if they don't serve you timely, that date probably gets continued. Either way, I would show up at the July 16th date. If you're aware of it, I would, not showing up. I always say just participating is half the battle. It's actually more than that. It's like 90% of the battle. Participating, make sure you show up to the hearings. And if they're out there, I don't ever tell people to avoid service. I know I get beat up all the time in the comments for it on all my YouTube videos. But if you try to avoid service, eventually they're either going to serve you or they're going to get permission to do what's called alternative service, where they just put it in the mail. In the old days, they used to put it in the classified section of a newspaper somewhere. So I just don't think it's too risky. You're going to end up with the default judgment if you try to avoid service. Just get the complaint, accept service, deal with it head on, and you're going to be in a much better situation. So, all right. Latoya says, I filed an answer for my $15,000 debt bought by a junk debt buyer. What's the next step? Well, it does vary a little bit from state to state, so it depends on what state you're in. But in most jurisdictions, the next step is what's called the initial disclosures. Usually within about 30 days, the parties have to exchange any documents, information in what's called the initial disclosure statement. So this is really when you're going to get their first, okay, you say you're in Texas. So you're going to get copies of documents, lists of witnesses, all that kind of stuff. It's also a time, if you have interest in settlement, I always say it's a good time to reach out. The creditor and their attorneys, they haven't put a ton of time or information into it at this point or work into it. So I think it's worth at this point reaching out to them and seeing it. Maybe if there's some kind of lowball settlement offers, there's no downside to doing that. Settlement offers are typically not admissible in court, so they can't use it against you. But the next step is you're likely going to receive all their information. And sometimes it's good to kind of see exactly what they have, and then you can make a decision from there as far as potential settlement. So, all right, let's see here. We'll finish up one more here. Says, I emailed the debt collector for the second time. They've not responded to, and my court date is approaching. According to the Consumer Financial Protection Bureau, they should cease collections. How do I stop them? Should I call them? Okay, so if they've already filed a lawsuit against you, what you're referring to there is if you send a debt validation letter, they're supposed to stop all collections until they respond to it, essentially. However, in this situation, if they've already filed the lawsuit, that's off the table. The litigation's already going. So, like I said, if they're not responding to you, you may just want to reach out to the court, find out what their procedures are, and make sure that you're following them so that you don't run into any channels or any other problems. All right. Steve said, just wanted to say thank you. With the help of your channel, I've won both lawsuits filed against me. Nice job, Steve. Nice work. That's a good one to end on tonight. I'm losing my voice already. But if you have any other questions, put them in the channel. I do go back, or you can put them in the go and put them in the comments and the videos. Something I will post. Ascend Finance is one of the companies that I work with. With bankruptcy, a lot of times people wonder if they qualify for it, or if they don't qualify for it, they'll wonder, if it's a Chapter 13, what's the plan going to look like? I'm going to put a link in here. This company is awesome. They have a free calculators that you can run the numbers online to help you determine if you actually qualify for a Chapter 7 or a Chapter 13, what that would look like. Check that out. Check out Solo Suit, those great people that we work with here. And with that being said,